Well, thank you everybody for being part of this Immigration 101 webinar. If I haven't talked with you previously, I'm Crystal Schroff. I'm the Attorney Support Director with Administer Justice, and I joined the organization in October. So I've been here almost just right at 6 months now. I want to turn this over briefly to Judy Miller now, who's going to talk about our Each One, Reach One campaign. And Judy is our Director of Advancement here at Administer Justice. Judy, you're on mute.
Oops. Yeah. All right. Common problem. Welcome. We have a wonderful group, a large group here today for a very important issue that comes up to our centers. And I want to just thank everyone for serving. You're in various capacities, but what you do is critical and very important. And we appreciate each one of you. You know that we're growing here and across the country. And of course, we're totally dependent. Your centers and all the centers are totally dependent on volunteers. We especially, of course, need attorney volunteers. Every volunteer is important, but for a legal ministry, the attorney is critical. And we know that attorneys know other attorneys. So I am encouraging you here with this Each One, Reach One campaign that we have to reach out to your friends, especially those attorney friends who share your Christian heart for serving the underserved and caring for our neighbors in need. You know your friends, you know their heart. You can share your excitement, your inspiration. You can share the joy that comes with serving, because we know the best way to recruit attorneys is by word of mouth, friend to friend, attorney to attorney. Tell them what you're doing. Tell them why you're doing it. And then if their curiosity is piqued, point them to our attorney webpage, give them my Calendly link, or send an email that introduces me to your friend. Just copy us both, and then I will take it from there. Right? Attorneys usually have very specific questions about malpractice, scope of representation, a range of issue areas of law and all, and I'm happy to talk to them about it. So I encourage you, please reach out. Thank you. And thank you for serving.
Thank you, Judy. So I want to move on to why we all really came today, and it's to hear from Linda Freyer. And Linda, thank you so much for agreeing to give this webinar. Linda was born in Texas and she was raised in New Mexico. She received a bachelor's degree in criminal justice and Spanish from New Mexico State University. And then after that, she headed off to Arizona Summit Law School and earned her Doctor of Jurisprudence. She has her own firm called DTB Immigrante, and I'm sure I did not say that right, but I love what DTB means, God bless you, in Spanish. She is located in Arizona, where she is licensed to practice law there. And she practices primarily immigration law with focus on family petitions, visas, employment authorizations, VAWA, and U visas. And with that, I am going to stop sharing my screen and allow Linda to start sharing her screen.
Good morning, everyone. Thank you so much, Crystal, for handing it over to me. Thank you for giving me the honor and to be able to present this topic today. I practice solely immigration law, and I really like immigration law. I really, really do. I like what I do. I have a passion for it. And I always try to do, or I always do my best with every single one of my cases. So today I'm going to bring you immigration law. Now there's a lot to cover, and let me see if I can move this so you can see the bottom. Okay, there's a lot to cover, and it's a little bit hard to cover everything, but I am gonna do the best I can to be able to cover the most important topics of immigration law, and in a manner that it's very understandable. Before becoming an attorney, I used to be a professor at the university. So I'm going to use my teaching skills and be able to hopefully assist in this manner and try to present the best information. Once again, thank you so much for having me here today. And thank you for being present for this Immigration Law 101 course that will be hopefully one of the first that we'll be doing to help teach immigration law when you have clients incoming to your centers and they are telling you, I'm about to get deported, please help me. And we are wondering what we could do for them. So I guess we're gonna go ahead and continue. Let me see, seems to not be, okay, here. Okay, I have to click. So we're gonna have the introduction, then we're gonna move on to ever-changing immigration law because that will always happen. And it's funny because sometimes, you know, we have the idea it's never going to happen. Sometimes we have the idea it is happening. Sometimes we will hear on the news that it happened and it did not happen. So that's something we're going to cover. I-130 petitions, we probably hear somebody talking about being petitioned often. We might not understand exactly what it is. BAWA, U-Visa, immigration law. We're going to go over FOIAs, which is ICE, CDP, USCIS, EOIR. And then we're going to go over how to help our client when they show up and they say, I have an immigration issue. I'm going to show you some tips on how to prevent immigration fraud. We're going to go over top 5 immigration tips, and then we're going to have questions and answers. So first of all, DTV vision. So as Crystal said earlier, DTV does stand for God bless you. And the name of the business is DTV Inmigrante, which is God bless you immigrants. We help the community, the immigrant community, live here, stay here, and fight for the right to a better future. It is a faith-based goal to spread the word of God to all our clients and PCs via our actions. I am Linda Freire, immigration attorney, licensed in Arizona, and I practice only immigration, but I do practice countrywide and in every country. So long as we're dealing with immigration laws of the United States, I am able to practice no matter where the client is at, no matter what state they're located, no matter what country they're at. New type of cases come out. So one of the things that we have often, and I should have put always changing, but one of the things that we have often in immigration is that we always have new cases coming out. So we could work on a case, especially for asylum, it happens very often. We could work on a case or be working for a client that has a case, and then something comes out. And that new something either makes it easier, makes it harder, or makes it not existent anymore. Sometimes it's as simple things as immigration saying we're going to change where instead of applying for a work permit in 6 months, it's going to be a year. Instead of paying no fee, it's going to be a fee. Even to the point of instead of sending the payment for the application in one, such as the application fee and the biometrics together, now we want to in separate money orders. Or it could be, now we're going to look into public charge. And that means you have to use this new form starting this date. With that, unfortunately, what happens many times is that we have a client we're helping for an adjustment case. And as we're helping them for the adjustment case, the law changes. And now the law requires that we submit public charge or we abide by public charge rule. So we will usually have a time frame where they'll say, as long as you follow the case by this date, then you're able to follow the previous regulation. But then if you wait and you file after this date, now you have to follow the new regulation. And that new regulation many times is something that's not going to help you, obviously. So we try to file the case beforehand so our client could benefit from that prior law. But it does happen in some circumstances that our clients are not ready, they haven't cooperated, and now we're a little bit backed up. Now, recently, for example, in December 23rd, we have a change of form. That change of form now required some questions that were kind of getting into the affidavit of support, which I'll be explaining later on. And it talked about public charge. What I did here in my firm, I spoke to my staff and said, hey, we have exactly 5 days to get the new cases out that are almost ready so that they are not affected by this new law, whether it is going to cause significant changes in the approval or not. So this is something that happens. I would tell you that immigration law changes so often that I constantly am changing my initial evidence list. I'm changing my secondary evidence list. I'm having to redo forms. Now, it doesn't happen every day, but it does happen. And whenever we have changes in the government, like a new president, anything like that, we're always going to have those changes. Not only changes when we file documentation, but also changes in the employees of USCIS, which is Immigration Agency, ICE, ER, which is the Immigration Court, or CBP, Border Patrol. The officers or the agents or the employees of those agencies will change as well, how they treat a client, how they process a client's case. Many times, depending on what change took place, they'll either become individuals that are likely to hear a client, understand the situation, either approve them or even if they deny them, but in a different manner and provide them options. Depending on what's going on in the country, they could also become people or individuals that say, no, it's just not going to happen. And I have had to sue many times. In one instance, I had filed a naturalization application, and my client had Alzheimer's and dementia. And the officer found that I had submitted a document for medical exception showing my client couldn't learn, couldn't remember what they were taught because they had those medical conditions. And the officer in front of me, I was there, said, those are not conditions that will affect you, the ability to learn. And that was very frustrating because my client was also blind. And one of the things that I had to battle, I had to file a complaint, I had to file amendments, which is like a lawsuit. It's a lawsuit because that was a completely erroneous assumption, but things happen like that. That anytime something changes in immigration, like I said, in the government or in any elections or anything like that, that will change the atmosphere of immigration law. Unfortunately, it shouldn't change, but it does. Court has its own manual, so they have their own policies. Here's what you need to know about court is that every single judge has its own requirements in a way. They prefer things a certain way. So you might have a judge that says, file the initial packet a month before your trial date, your individual hearing. And you might have a different judge that says file it 2 months, and you might have a different judge that says file it 2 weeks before. So we're always gonna have that differences. And they'll give you now what they're called scheduling orders that kind of have their preferences. They'll sometimes require you to submit a brief, and they'll say, no, just a certain amount of page brief. And others will say, yes, we want a really long brief. And some will say, I don't want a brief at all. So it depends on the judge. There's a policy manual that EOR court, which is immigration court, has, but you still have to deal with the judge's preferences. And lastly, clients, the past determines their future and immigration options. that there's no one client you're going to have that's unique at all. There's no one, even if you have two clients that are twins and married to two twins, and they have both one child, they got married the same day, it doesn't matter. There's no one case is the same, because there's every tiny little detail might affect the outcome of opening a possibility and closing a possibility. So that's something I wanted to start off so we kind of understand from here on when we start presenting on the rest. So I'm going to cover many topics, many immigration solutions. So if you want to take notes or questions, write down your questions. And then when Crystal opens it up, then we could put the questions. I also understand that they could put the questions on the chat, and then we could go over those questions at the end of the presentation. But I will be covering a lot of topics. The first topic I'm going to be covering is the I-130 petitions. Now, we often hear these as petitions. We hear them as I-130s. We hear them as my wife wants to petition me. There's so many different manners. Sometimes we hear it as somebody's filed something for me. My mom filed something for me. My husband filed something for me. That often happens. So there's two types of I-130 petitions. We have the spousal petition, which is husband petitioning wife petitioning husband. We have the family petition, which is siblings, parents, and children. Children petitioning mother, father, parent petitioning children, sibling petitioning siblings. Now, all these have many possibilities. So you could have, for siblings, it has to be a United States citizen sibling petitioning another sibling. For parents, if the parent is a legal permanent resident, he may only petition children that are under 21, not married, or over 21, not married. They cannot petition married, under 21, or married over 21. Now, if the parent becomes a U.S. citizen, now they're able to petition basically married, unmarried child, or adult child, son or daughter. Now, children have to be U.S. citizens if they want to petition their parents, and they have to be over 21. So in all these cases, for you to petition, you have to be over 21. That's very important. That's something we need to make sure, because many times I have run into cases where somebody comes to me and says, we already filed a petition, I just want you to do a second step. And I always will tell them, bring me the petition, I want to see what you filed. In some of the cases, I have found that they're filing petitions, or their son or daughter are petitioning them. This is usually the parent coming to me, and their son and daughter are only 18 years of age, and they can't petition them. So we need to make sure they understand that it's only going to get denied, they're going to lose their fees, and we don't want to do that. Some evidence stays the same for every case. And what I mean is, like, we're always gonna need like a passport, an ID, a birth certificate. If it's a petition between husband and wife, a marriage certificate, marriage license as well, because they're two separate things. And some will change. So you'll have clients that say, I have my marriage license, I got married in so-and-so country, and they don't issue the marriage license. So then you have to go into the Department of State, and there is a table, or there's a section that tells you based on the country what kind of documentation it's proper to prove that there is a valid marriage that occurred between them. Sometimes if you're dealing with a country that where they got married was via a tribe, they have to get a special certificate from the chief. Sometimes some countries will not give you a certificate, but they will allow you to put your name on, I don't know, a car together, or they have provisions saying you can't put nothing together between both of you unless you're married, and they don't give you a marriage certificate, but if they recognize the marriage occurred, then they allow you to do X, Y, and Z, and then those tables at the Department of State will tell you what country and how that looks. It would also tell you exactly how, what place the person should go to. So if it says they have to go to RENAP, for example, Guatemala, it'll say they have to go to RENAP, and then they have to ask for this document, and the document is gonna look like this. And they won't show you a picture, but they'll describe it. So when you're client is giving you the document, you have to make sure if it's from a different country that it's meeting those guidelines, because if not, immigration will usually send you a RFE, which is a request for evidence, saying you need to give me the right paper. So we need to make sure that, you know, the first step to attain their green card, but might be able to be combined with a second step. So when you're dealing with a case, some cases you're able to combine them with adjustment of status, which is amazing if you can, because adjustment of status causes the case to move much faster, allows the person to obtain a work permit. Allows them to obtain their green card inside the United States without having to leave back to their country. So that depends on the client situation, on the past and how they enter the country. Usually we'll see often, this happens very often. A 21-year-old son born here in the US wants to petition their mother. Their mother entered the United States many years ago on a visa, and they just never left. And there's no other issue. They never had, like, they never tried to cross illegally. They never got caught with, you know, doing something bad. They were never in jail. They were never deported. So now the client comes to you and says, I'm 21. I want to petition my mom. I want to get my mom a green card. What can we do? In that kind of a scenario, you're able to do a petition and an adjustment status packet. And I'll be going over that as well later on, but you're able to do them together, and that allows you to also ask for a work permit for their mother, and even a advance parole, which allows them to go back to their country during the process while the process is pending, without it being considered abandoned in case they had an emergency. So let's say they have a really sick family member, and let's say often you'll see their mother is really sick, or their father, and they want to go see them before they pass away. You're able to submit this and allow them to get that advance parole so they could go back home, meet mom and dad, or see them again, and be able to travel back without being left outside the country. And then still continue with the process without the process being terminated. So you can combine them at times. Sometimes you cannot. Sometimes, and people will tell you, yes, I can. And you'll have people come to you and tell you, yes, I went to this attorney and they told me that I could get my green card inside the country. And you need to make sure, and I think we all have to understand that we cannot get secondhand information from them, or they tell you we went to a prior attorney, because many times it might not even be an attorney. It might be an attorney that doesn't really focus on immigration law, and maybe they just logged into USCIS and said, oh, yeah, I think you can. Maybe they didn't present them all the information. Clients will often and can often lie. So you need to make sure that you're very direct in what you're asking them to see if they're available, because they're eligible for this. Because if you file adjustment status for them and they get denied, then they will be put into removal proceedings, which means a judge will try to deport them from the country, remove them from the country. Watch out for fraudulent marriages. This happens a lot. You'll see often two people getting married because one is a U.S. citizen and he or she getting married to the other person who's undocumented so that they could fix their green card, obtain a green card for them. You need to be very cautious with this. How do you detect those? For me, it's because I'm doing this so often. It's kind of, there's certain questions I ask and they hesitate, or there's certain questions I ask that if they don't have an answer for, can I click, oops, this might not be a good marriage. What this means is they must have been married for love. Now, they get married and now husband wants to petition her. There's no problem with that, with them wanting to get a green card. The problem is that what was the purpose of their marriage? And, you often want to ask, many times you'll see them having children together. That is a really good sign. That's probably not just marriage because of documents, because of getting a green card, because you probably don't want to have a child with someone you're just passing through the time frame to try and get your green card. They usually will not want to combine any assets together, such as they don't want to combine joint bank accounts, which is evidence you have to submit a good faith marriage with those type of husband and wife with spousal petitions. So if you don't see them combining any assets like the bank accounts, like the rental agreements, if you don't see them talking about trips together or even living in the same house, those will all give you that like red flags of this might not be a valid marriage. Now, you also have to try to see if you could detect any abuse going on, because if one of the parties, husband or wife, whoever is being abusive toward the other, one way of keeping them or control over them is to prevent them from, having joint bank accounts, access to money, ability to be on the house lease, because then if they get mad, they could just kick them out. Maybe they don't take trips together because you stay home and I go. So you want to also make sure that there's no abuse going on, because if that's the case, then you could still help the other party if they're undocumented, but it would just be a whole different process. And we'll talk about this later on this morning. You need to make sure that they also don't have any order of removal. This is so important, and this is a topic, a situation that many attorneys leave out or escapes their mind. You do not want to file any type of petition for anybody or file anything with immigration if you know there's an active order of removal, because once you file, like in this petition, you have to put the address of the person, and if there's an active order of removal, it's like a warrant for their arrest, immigration warrant for their arrest, you will have ICE officers show up to your door and detain them, or they'll be requested to go to USCIS, that's an immigration agency, to do what we call a stock interview, or they call it many things, but it's just to have both parties there, and while they're there, talk about whether they're really a valid marriage. But if you have an active warrant for their arrest, or I would say an active removal order against them by a judge, then likelihood that ICE will show up and detain the undocumented party will occur. Like I have seen it happen. We do have changes in law, new memorandum that came in that shows that there's the priority, that they're going to go after individuals that, even if they have been removed, but that actually also have a really bad, severe criminal record, and they go after them first. And then, they're the first priority, right? So, but you still want to put your client in danger. And if your client wants to go ahead and try it, you need to inform them that, that could be an issue, and that, they just need to be aware. I have had clients that say, I don't care, just do it. They're tired of being in this country illegally and being afraid, and they're just do it. So I will type something up that says, hey, I explained to you that this is a situation and you still want me to proceed, and you understand this can happen. I explained to you the risk and the benefits and all this, legal jargon, and they'll understand it, they'll sign it, and we'll continue on. I try to help my client, but at the end of the day, they're the ones that decide. There has been a few times where I have said, sorry, I can't do it. You're more than welcome to go somewhere else. I guess as an attorney, the reason why I became an attorney was to really help people. Prevents me from doing this because I 100% see something bad happening, and I will not do it. And sometimes, it happens when somebody says, I did cross the border many times, but please don't put it on the application. And I'll be like, yep, that's not going to happen. I'm sorry, I'm not going to do that. Since you told me, and now you told me, I have to put it on there because it's specifically asking for that question, and I can't go around that. Because the client, the immigration is going to find out, and when they do, client could be detained, could be deported, could be denied, and they're going to come back to you and say, well, I told you. Beneficiary equals undocumented client. You'll see that on the I-130. Beneficiary is who's receiving the benefit, the undocumented client. Petitioner's family member, who is a United States citizen. You'll see USC. LPR is a legal permanent resident. LPR, legal permanent resident. USC, United States citizen. And even if the person, and this happens often, even if the person has DACA, even if the person has a temporary protection status like TPS, they're still considered beneficiary in this application. So even if they're not 100% documented, maybe they have a temporary permit to be here, they're still considered a beneficiary because they're not U.S. citizen and they're not, they don't have a legal permanent residency, which is their green card. BAWA. If I'm going too fast, please let me know, Crystal, so I could slow down. I think you're keeping track of time.
Yeah, I've answered a few questions in the chat. Perfect.
So BAWA is an act that was passed by Congress to protect the victims of crime, or that have been victims of crime that do not report to the police. It's not U visa, but it's something kind of similar. BAWA stands for Violence Against Women's Act. Now, when we hear that title, we probably think it's just for women that are being abused. No, it's not. Who qualifies? Parents of abusive U.S. citizens, son or daughter. So as we said, USC means United States citizens, son or daughter that are 21 and over. So these are parents. It could be mom, it could be son, it could be father. So you have a 21-year-old U.S. citizen born son or daughter who abuses you. That could be about, that is about what if they're being abusive toward you. Maybe you're married to a legal permanent resident, and here's a change, because for the son they have to be a U.S. citizen over 21, but your spouse could abuse you, and they could be a United States citizen or a legal permanent resident. And that's important because sometimes we think that only if my husband or my wife is a U.S. citizen and if they're abusing me, that's the only time I can submit a BAWA. No, it's not. If they're a legal permanent resident as well, you can submit a BAWA if you're being abused. Child of abusive LPR, United States citizen parent. So this is the child being abused by their parent. So the first one is the parent being abused by the son or daughter who is a U.S. citizen. And now we're talking about the child being abused by their parent who's a United States citizen or a legal permanent resident. Now, stepchildren and step-parents also benefit. And this is something I left out on the first one, but you could also petition your step-parents and you could also petition your stepchildren. For the I-130, and I'm sorry, I'm gonna go back a little bit. For the I-130, as long as the legal relationship occurred before the child was 18. So let's say mom who is undocumented, or and she marries a U.S. citizen man, and when they both marry, mom has a 12-year-old son or daughter who's also undocumented. Let's say, in that situation, because the marriage occurred before the son or daughter is 18, the stepdad, which will be legally the stepdad at that point, or, you know, the U.S. citizen man, husband, he could petition the 12-year-old as a stepchild. Now, when they married, if that child was actually 18, then he couldn't, because the relationship has to be established before they turn 18. Now, this is the other way around too. Let's say mom has a 12-year-old son or daughter who they're both married, they're both living in the U.S., or, you know, and sorry, let me backtrack on this. Let's say mom has a 12-year-old son or daughter who was born here in the U.S. She marries a man. Man is also undocumented, maybe the same as mom. It doesn't really matter if mom is undocumented or not, because when they married, the child was under 18. Once the child grows up and turns 21, he could petition both. That's how the stepchild petition works. Step-parent petition works. And like I said, we have to prove only that the marriage occurred before the child turned 18. And in BAWA, this also applies. You know, if the step-parent is abusing you and they're a U.S. citizen, or the stepchild is a U.S. citizen and they're abusing the parent or the step-parent. What type of abuse? Physical, emotional, sexual, battery, extreme cruelty. So one of the things with BAWA, and I'm gonna really differentiate this from U visa, because you might hear something as U visa. BAWA, we do not need a certification, so you don't have to send a document into the police department so they could sign it saying you were a victim of crime and you cooperated. That's basically what that is. You don't have to have that. You don't even have to file a police report. U visa, that's required. Here you have to prove there was abuse. So abuse could be physical, emotional, sexual. I mean, you could combine it. Sometimes what we see often in Bagua, where the children are being abused, where the children, the U.S. citizen, son or daughter is being abused toward the parents, is that there's absolutely no police reports. Why? Because mom or dad, even though they're being abused by their child or their son or daughter, don't want to call the police because they're afraid that their child, son or daughter are going to face consequences. They're going to be detained, arrested, they could lose their job, they could lose a scholarship. Maybe they wanted to join the military, but now because of this, they can't. So they're really afraid to cause harm to their son and daughter, even though their son and daughter are abusing them. If that's constant, I see that, I think in so many Bagua cases I have done, I have seen, I would say 1 out of every 10 Bagua cases we file will have a police report. And it's usually because son or daughter is so physically abusive that somebody else called the police, or maybe the parent did call the police, but it was just so severe. Abuse could be physical, emotional, sexual, battery, extreme cruelty. And extreme cruelty, many times we don't have physical, or if we do, there's no evidence, or if it's just, it's something that they don't want to talk about. Emotional, but extreme cruelty happens, let's say that, and this is something common, and I do see this a lot with children, with son or daughters who are over 21 that are abusing their parents, is the embarrassing them in front of their friends, saying something like, oh, you're illegal, or you're ignorant, or you don't even know English, or you know nothing, or you're dumb, things like that. And that embarrass them in front of the other people. So you want to, I always ask them, is there somebody there when this is going on? You know, because at times I have had situations where the son or daughter like will throw the food at the parent and say, eat it, and they'll throw it to their face, they'll flip food over their face, they'll throw stuff at them. And you know, that could rise to that extreme cruelty. We see sexual abuse a lot happening in between the spouse who's abusive, even parents who are abusive to their children. We see that going on a lot. Emotional abuse, calling them insults, comparing them to, you know, there's so many things they could say. And physical abuse, which is actual aggression. Like I said, a police report is not required. And this is important that we all know, because many times we confuse Bagua and U visa, and we think that unless we have a police report, we're not going to be able to help them. And many times I see a lot of attorneys that will say, oh, you don't have a police report, sorry. You just, you know, I know you have a U.S. citizen son or daughter that's abusing you, but you don't have a police report. You know, there's really not much evidence. And that's false, because there is a lot of evidence that you could help them obtain, such as if they don't have a police report, but you could do a declaration, you could do a psychological evaluation, you could get articles as an attorney, you could, you know, look up different articles, look up case law, you could get news reports, you could get letters from families and friends, you could get pictures, you could get copies of the text messages, if they have recordings. There's just so many other types of evidence that you could help, that they could collect to prove they've been abused, that does not require a police report. Many times I think it's just that because it is harder to get that evidence, but we cannot tell a client they can't just because they don't have a police report. That is not correct. You could file Bagua by itself or with adjustment of status. Here, there's AOS is adjustment of status. As we spoke earlier with the I-130, Bagua could also be combined with adjustment of status. Not in every case. Not in every case, because if the person is going to be considered inadmissible, because that's adjustment status will really check into inadmissibility. So if they cross the border illegally. Here in Bagua, if they cross the border illegally, let's say only once, and they never had problems with police, they never were arrested, detained, they were never sent back home, removed, had judge, you know, see an immigration judge or anything like that, then even if they cross the border illegally, as long as they only cross once, Bagua allows them to be, in a way, eligible for adjustment of status, so they don't have to have entered with a visa. They could still get their green card inside the country just because they're a victim of one of these situations. and you file BAWA. But if the person has been to the U.S. And crossed the border several times, even if they're eligible for BAWA, you cannot do adjustment of status. And we need to make sure we know that, because if you do adjustment of status and they're inadmissible and they get denied, they could still be sent to immigration court. Of course, since if they have BAWA by then, you could let judge know they have BAWA, which means they're basically in status. And the judge will usually close the case in court, but you don't want to put your client through that. And it's also more work for you. You need to look for deadlines to file. So you can still file for BAWA if the person who, let's say, for spouses, right? If your spouse is abusing you or abusing your client, and they got divorced last year in May, you can still file BAWA. You have 2 years from the point of divorce. Now you have to make sure that you file BAWA before those 2 years are met. So if they got divorced in May of last year, then you have till May of next year to make sure the application is in with immigration so they could still benefit from BAWA. You also have to make sure that if let's say the spouse was a legal permanent resident and they're the ones that are abusing their spouse, and you're filing BAWA and you're helping your client is the abused spouse, you're helping them get their green card. Even if the legal permanent resident spouse lost their green card, you could still help them get the BAWA so long as the reason they lost the green card was because of the abuse. So if you're a legal permanent resident and you're abused, you get detained and go to jail for domestic violence, eventually that could cost you to lose your green card. So if they lost their green card because of that, know that they could still file BAWA. You just still have to make sure you hurry up and do it before your time runs out.
Linda, real quick question before you get off this particular topic. There was a question on the age cutoff of who is a child.
21.
21?
Under 21 is a child. Over
Okay.
21. I know because of the sometimes we consider adults at 18, but for an I-130, they have to be over 21. So that's how they consider it. Now, for BAWA, you could still add the derivatives. So let's say that you're, let's say that abusive U.S. citizen spouse is abusing their wife, and wife has 2 other children, no matter whether at Mexico, whatever, anywhere, any state, but they're underage and they're documented, then mother is able to add her children to the BAWA. She's being abused, so she could add them as derivatives. There is cutoff lines when it comes to sorry, I'm trying to make sure I get all this up. There's cutoff dates when it comes to the age, but you can still argue in BAWA that you could potentially still add your 23-year-old or whatever son or daughter if maybe the abuse was so severe that it prevented you from filing earlier and they were abused as well. Does that answer your question?
Yeah, and one follow-up question to that. Does that age difference change if there's a disability involved?
That's a really good question. I never run into that issue before, usually because I'm still helping the client with the case, regardless of the disability. But if we have, like, for example, they have a child with Down syndrome that is maybe 25-year-old, but their age is actually a 7-year-old, I think it would be a really good argument. I think it would be a good option to try it and just argue and do a brief with immigration and say, look. But in this case, let's say that they're able to get adjustment of status. I would not do adjustment of status. I would just do BAWA, because if BAWA gets denied with that argument, then you should still, it won't cost you to be removed proceedings. Does that make sense?
Yeah, thank you very much.
You're welcome.
I'll let you move on.
Okay, perfect. Okay, U visa. So U visa, and I was trying to pull up on my other computer, but the crimes, I will pull them up here. So victims of crimes, there's so many crimes a person could be a victim of. but not every single crime will fit into U visa. So what U visa requires, this is the very first step. And if this doesn't happen, you cannot file a U visa case. This is 100%. The person had to have been a victim of a crime, of one of the crimes I'm going to be listing in a few seconds. They must have called the police. They must have pressed charges. And they must have, or aided in persecution, which is answer the police questions. If the detective calls them, answer them, give them the information. Now, there's times that maybe there's a DV case and the police will arrest the husband or wife, and maybe they're in a state where the person doesn't even have to say, I want to press charges. That they could just press charges because of what the state law says. There's domestic violence, we're going to press charges. But if they ask you questions and you're like, no, I just don't want to be involved, they're going to write something in the police report that says you failed to aid in persecution. So later on, if you come to an attorney and you tell them, well, I've been a victim of domestic violence. Yeah, the cops even came to the house and they arrested my husband or my wife. Yeah, they tried to stab me, they tried to choke me, whatever it may be. The right thing for you to do is to say, where's the police report? You want to start by reading the police report. If on the police report it states that they failed to aid in persecution, there's nothing you can do. You cannot continue helping them because they will not get anywhere. Why? Because you need to have the police report, the police department certify a document, which is an I-918 Supplement B, and that could only be certified, once again, if there was a victim, if the victim was a victim of one of the crimes I'm going to be listing in a few minutes, if they cooperate with the police. So if the person says, no, I just don't want to do it, or I'm afraid, I just don't want to press charges, or I just, just don't call me anymore, or whatever it may be. If they fail to assist the police and the police note on the police report, it will not get certified. It will not get certified. Even if it goes to the prosecution. Now, you can still argue with the prosecution, but the prosecution is probably going to look at the report and say, well, you didn't even want to help. You didn't want to press charges. So the victim has to aid in persecution. They have to. There's no way around. Even, oh, I was afraid. That doesn't help. That doesn't count. Once that certification is signed, then you move on to the actual U visa process. So I'm going to go ahead and show you this list. So here, you could go to USCIS website and just pull the 918. And here is a list of the crimes that the individual could have been a victim of. And the most common ones I see are abusive sexual contact. This could be something like your client is walking down the street and somebody goes up to them and, touches them inappropriately. It doesn't have to be an actual like sexual assault. It could be considered sexual assault, but it doesn't have to be an actual rape. We often see a lot of domestic violence, a lot. This is so much. Felonious assault. Now, sometimes you see that somebody wants to file wants to start a U visa because maybe they were driving and there was a drunk driver that hit them and they got really injured, and they want to claim felonious assault because the drunk driver was using their vehicle to cause them harm. And it really depends on the police department whether they're going to sign it or not, whether they're going to consider felonious assault. But I can tell you that immigration-wise, I haven't really been seeing much from them saying it's okay. I have spoken to a few of my colleagues because we all do different types. We do about U visa, but we all have different reasons why we're doing U visa for a client, why they've been the victim of. And that hasn't really been something that has really been approved often. Felonious assault is also not where your client is walking down the street and maybe they just cashed their check and somebody comes up to them and says, give me your money or I'll kill you. Or give me your money, I'm going to beat you up. And they hand them the money and then the person takes off and then they call the police and they're like, yeah, I was assaulted. And it will still be considered assault, but if it's not considered to level of felony, it's not going to make it. For here, usually we see the assaultant, the offender coming to the victim and pointing a gun or having a bat, or trying to hit them, or even hit them with a bat, or whatever it may be, using an actual deadly weapon or a weapon to cause them to do something for them, such as giving them their car, giving them money. That's when we see the police actually labeling as felonious assault. Kidnapping. If you have kidnapping, if you have involuntary servitude, if you have domestic violence, abusive sexual contact, sexual assault, rape, slave trade, you also want to look into T visa or trafficking. You want to look into T visa, which is a human trafficking visa, because the human trafficking visa has a shorter wait time. U visa, we're looking at 6 to 7 years before they get an actual approval of the U visa, because of the change that happened I think 2 years ago by President Biden. He now gives them a work permit during the time that the U visa is pending, but that work permit is taking years before, because they have to catch up with everyone that has filed in the past. But the T visa is much faster, much faster. I mean, it could be 2 years by the time, that they get their T visa approved, and then that also allows them to get a green card later on. So you want to look into those, and you can file both of them. You could do a U visa and you could do a T visa. I have people file T visa, U visa, and BAWA. So you could have several of those cases, and it should not affect either of them. It will not affect either of them. A rape, all these different types of crimes that if your client is a victim of could constitute them that they are eligible for U visa. Now, just because they sign, they sign the certification doesn't mean 100% that they're gonna get the U visa approved, because sometimes you will have officers. This is so silly, and it happened to me. A potential client came to me and said, I want to start my U visa. And I told them that they brought me the certification. I said, you can't start a U visa. Yes, I can. I have the certification. I said, I cannot help you with a U visa because you don't have a merit for a U visa. That particular client got really upset at me. But the reason why was because the certification said, and it was signed, it had their name, it said they cooperate with the police, but there's a section where it asks to check mark what they've been a victim of, and the police officer had drawn in a little square, put a check mark that says none apply. Well, if none apply, then even though they have been a victim of something, they can't continue on to a certification. That there is no way, because none apply, none of the crimes apply. And I'm not sure why it even got signed, but it did. Now this potential client is mad at me because I wouldn't take their case, but there's something I could do to help them. But you need to make sure that you also read the certification that they bring it to you, because not every single time an officer signs the certification, they truly know what they're doing. Sometimes they don't get the training, they just get told you're going to be doing this, and here is a piece of paper and read it. And sometimes they just sign every single one on without knowing what's going on. Sometimes they don't sign the certification when they should. For example, sexual assault. I had a client who was abused, they were a minor, by this individual, but because they were never penetrated, they were only touched, they did not consider that sexual abuse or assault. And this has been 2 years now that I've been fighting with that police department I'm hopefully soon, I'll be training those officers so they can understand what really does constitute, a crime under U visa, which is kind of silly, but it has happened. And I do have a few trainings hopefully coming up to be able to really teach them what it means. So U visa. Process victim of a crime, reported to the police and press charges, aid in prosecution, request and obtain the 918 Supplement B certification, gather evidence, and complete immigration forms. This is how you would go about the case. So if you're working with a client, and you probably will see a lot of U visa, BAWA clients coming to you because they're victims of crime, domestic violence. They usually have no money, so they're gonna go seeking help from organizations, and like the legal clinic is a perfect place you could go to. You need to know that you have to tell them to bring their police report. If they don't have it, they could talk to you about the crime, the situation. But I would say, look, get the police report and schedule another appointment, because they could tell you one story, but then there's a whole different story in the police report. And unless the police report specifically talks that they've been a victim or states they've been a victim of one of those crimes and that they aided in persecution, you cannot move forward because you need to get the certification. I find it silly sometimes with potential clients that tell me that they went and paid for a certification and it was never granted to them. And I ask them questions, when did you go, and all these other, questions. And I come to find out that the person who said, I'm going to get you the certification, never even looked at the report. They just took for granted. They just took whatever the client told them, and they said, okay, fine, let's ask for the certification. I charge for a certification. So, and it's not super cheap. So you don't want to do that for the client. If you see the police report and you see that this is, they failed to aid in persecution, you're the one that sent out for a certification, and, have them waste money when you clearly see they're not going to get it. So you want to make sure you look at the police report. You request the certification. Once that comes in, once the certification, you have it at hand, you see that's properly signed, that certification only lasts for 6 months. So you need to make sure that if you're putting a case together, it leaves before that certification expires, because you go from the date of the signature 6 months forward. So you want to make sure you send it. I always try to send the latest on month 5, so that way, you have to mail it in, whatever it may be. And sometimes immigration messes up and sends it back to you and says, we need a fee, and you really don't have to send in a fee. So then you resend it back. So you need to make sure that you send it before the certification expires. If the certification expires, you could always request a new one, but some departments, police departments, will tell you that they will not give you a new certification. They only do the one time. So if that happens, then you can't continue anymore. Then you gather evidence and you complete immigration forms, you file with USCIS. They will go to biometrics appointments. Several years later, 6 to 7 years, USCIS could approve your case, and you will get a U visa. And after they get the U visa, they'll get it for 4 years. And after being present in the US with that U visa, because some people get the U visa and take off, and they shouldn't be doing that because then they can't get their green card. But they get the U visa and you've been in the US for 3 years. Even if the U visa still is expiring, you have 1 more year left. At that point, you help them apply for a green card through adjustment of status, which is amazing for this type of case, because they do not have to get a sponsor to sponsor them. They don't have to meet the public charge. So if they're getting food stamps, Section 8, whatever it may be, is not going to affect them. They could apply for a special waiver, fee waiver, so they don't have to pay the $1,225 fee from USCIS. And then the biggest thing of this whole process right here with the U visa is that it has this amazing waiver, not the fee waiver, but it's a different waiver, that if they have ever crossed the border multiple times, they have a criminal background, they've been removed, all these sorts of different consequences they could have faced criminally in immigration. And it is not every single one, but most of them, even the permanent bar, will often be forgiven when you submit that I-192 waiver with your adjustment, with your U visa case. And you will submit it when it says complete immigration forms right here. You will submit it along with those forms. Oops. You will submit it along with those forms. Okay.
Linda, quick question that someone has.
Mm-hmm.
If there is a pending U visa and a VAWA petition, can a removal proceeding be initiated against the petitioner?
Yes, so they could still be placed in removal, but then you could close the case by showing the judge that they have this pending, situation with the client. Usually you want to talk to the prosecutor and say, hey, my client has, we already filed for the U visa, we filed for the VAWA. Can we, dismiss the case? Or can we place the case on admin closure pending whatever comes out of this, VAWA or U visa? But can there be a removal proceeding against them? Yes, there can. Matter of fact, there's a special BAWA that you could file when the person is in removal proceedings. Good. Does that answer your question? You're welcome. So then you can submit that amazing waiver. Once again, is an I-192 waiver, and that in Spanish I call it la buena gente waiver, because it's really nice. It's like your best friend, and it's gonna forgive you for a bunch of things. You file with the U visa, and it really does forgive you for a lot of things. It doesn't forgive you for everything, but it will forgive you for a lot of the things that will prevent you from getting your green card via petition or any other method. So once you submit that waiver and it gets approved, when you do adjustment of status, and you know how we were talking earlier about inadmissibility, that if you're inadmissible because you committed a crime, you crossed the border several times, they'll usually cause you to be denied. Well, that waiver really forgive you, so they really cannot use that against you when doing adjustment of status, and you'll get your green card inside the country. Once you have your green card, then 5 years later, from being a legal permanent resident or having a green card, you could apply for naturalization. Also, U visa allows you to add derivatives. So if you've been the victim, let's say my husband and I've been the victim of a crime, I'm undocumented, he's undocumented. We are legally married, and it doesn't have to be where I was a victim of a crime, you know, last year, and me and him and I got married 20 years ago. It doesn't matter when we got married. It just matters that when we're going to continue, when we're going to start with the visa case, and if I'm going to submit him to be a derivative, that we are actually legally married. And there's a timing too, because if the U visa case is already got awarded the U visa and he was never included, then he might not be able to join me. But if I submit the U visa case and then boom, I meet him later on, I fall in love, my case is still pending, you know, then I could submit his U visa case as a derivative. And he'll come into my case and he'll still benefit from the U visa. And it's all because I was a victim of a crime, but he benefits as well, and my children benefit as well, even if they're in a whole different country. So if I'm here in the US and I was a victim of a crime and I qualified and I did everything I had to do and I filed everything, and I have a 14-year-old son in Mexico, never been here to the United States, I could file U visa for myself, include my son as a derivative of the U visa. And when the time comes when I get my U visa and my son gets a U visa, then he'll go to interview at the consulate and he'll get his U visa and he'll come into the country with a U visa, which is amazing. But the crime must occur in the US. So if the crime occurred in Mexico, that's not gonna do anything for me. The crime has to occur here. Also for BAWA, I have to have been the victim of, you know, of somebody that's a U.S. citizen, but it's important that it was done here. If, let's say, my spouse is in the military and we had to go to Mexico and he was in doing some work in Mexico for the military, then if he abuses me, it still counts because he was still doing work for the army or the military or whatever it may be, or we went to a country that has a military base and it happened in the military base, it still counts. So that's a real amazing thing to know. But also do understand that even if you have been a victim of a crime, and this is one question you're going to come up about many times when somebody tells you, but I was a victim of a crime 20 years ago. Well, as long as there's a report and you cooperated, you can still file the U visa now. And if you do have a client that is in removal proceedings and maybe they don't qualify for asylum, they don't qualify, they don't have enough time to be a 42B, which is cancellation and removal, screen them for every type of visa, because if they are a victim of a crime, human trafficking, they are married to a U.S. citizen, but maybe they cannot adjust because they have, they crossed the border several times, but you could still, they've been abused by their spouse, and you could just get them the BAWA. And at that point, you should be able to reach out to the trial attorney and say, hey, come on, let's close my client's case. He has a possibility, and here it is, and we're ready to file. So you want to make sure you screen them for all these type of cases. Every single consult I do, I always screen them for every single case, and it does not take long. Immigration court, EOIR. If a client fails to appear to immigration court, they will be held in absentia, and they will be ordered removed. There is no, I'm just not going to show up because they're going to detain me. That's actually not usually gonna happen unless they haven't showed up and now they decide to show up and they already had a removal order. The person usually comes to this country illegally or however, and while they're here, they get, something happens. It could be they committed a crime and they went to jail, and because we're in Maricopa, the moment they hit jail, there's kind of like, there's a process they go through where they identify whether they're illegal or not. And if they're illegal, they get what's called an ICE hold. It's kind of, for me, it's kind of like they just put like a little mark saying, oh, he's illegal. And that nullifies immigration. So when the person is released, even if the family comes and pays the bond from the criminal court, they're not going back to family. They're going to immigration. And you're just paying for them to be released to immigration. And I usually tell my clients, don't pay for them. If they're illegal and you're in a country, in a state where they have ICE holds, don't pay for their bond at the criminal court. Just leave them there, save that money, and try to figure out how you're gonna battle this immigration situation. Because the moment they're let out, they're going straight to ICE. They're not gonna be released to you. But if your client has their first hearing, second hearing, and they just decide, I'm not going to show up because when I show up, they're going to detain me and deport me back to my country. That's not how immigration court works. The person will come into the country illegally. They somehow make it to immigration court. Once again, it could be a criminal act, or it could just be as simply as they're driving and their tail light is broken and the police detains them and they find out they're illegal. And the police officer sometimes doesn't even write a ticket. They call ICE and wait for ICE to get there, and then they take off. That happens a lot, which is, it's illegal. They shouldn't be doing that, but it happens. So then they make it to ICE, and ICE will give them what's called notice to appear. It's a document that says notice to appear at the top, and it'll say that they have a master calendar hearing. Master calendar is just like a check-in hearing. It's like showing up to court and, hey, I'm here. And then they do pleadings and all that other stuff. And I'll go more into detail. But if the client says, I'm just not going to show up. I'm just not going to show up because if I show up, then this is going to happen. I'm not going to show up because they're going to detain me. I'm not going to show up because they're going to arrest me. I'm not going to show up because I'm afraid. They don't show up, they automatically are held in absentia, and there's an order of removal against them. Like, that's it. Their case is closed. The judge will see it like they just don't care to continue on and try to fight it. We're just gonna go ahead and remove them. And that's the worst thing they could do. So if you have somebody that tells you, I'm not gonna show up, even if there's their final hearing at immigration court, they need to show up, because even if they lose the final hearing, they could still request to appeal, and that will give them an opportunity to stay here in the country more years. So they need to show up. Court consists of several types of hearings. Most common are master hearings and individual hearings. And I'm sorry if you're hearing some background noise. I think someone's cleaning their landscapers outside, so I'm sorry. But the most common hearings are master hearings and individual hearings. Master hearings are hearings where the person is showing up. They could be with an attorney, they could be with themselves. Usually the first hearing, people, if they just arrived here to the country and the first hearing is within a few months, they don't have money to hire an attorney. And, that should not prevent them from showing up. They still have to show up. So let me know, Crystal, that's really loud. I'm sorry. They still have to show up. And if they show up, what that does is that it allows them to hear their case out, and they could request the judge time. It's like a continuance. The judge will then ask them, do you need more time to speak to an attorney? And they'll probably say, yes. Okay, I'm gonna give you another day, but you need to come with an attorney, and then they'll schedule them a different day. Laws with immigration could change, policy procedures could change, where they might actually say, no, we're going to do it more often. From now on, if you show up with no attorney, then that's it. We're still going to continue. And that can happen. But at this point, that's what's going on. You could request more time. The other thing as well is that you're able to go into court, and they usually ask you, how do you plead? And that basically says the notice of appeal they gave you earlier will say all these charges against you. Will say you're not from this country, you're from this country, you were not admitted, you crossed the border on this day, all this other stuff on the NTA, and they'll ask you, are those allegations true? Is it true that you're not from the United States, that you're from Guatemala? Is it true that you were not admitted? Is it true that you crossed the border on this day? Usually you'll put the cross the border because maybe they caught you crossing the border, or the day that you told them you came in, if they got you within the country. So that's where you're gonna have the allegations. At the bottom, you have the removal charge. And the removal charge, you either say, I contested, or I agree, or I don't. If you accept the allegation and you accept the charge, that doesn't mean that because you accepted the allegation, you accepted the charge, automatically you're deported. It just means that that's the proper charge they should be removing you under. So if you are a legal permanent resident, you have a green card, you can still face removal proceedings. They cannot put a charge to remove you because you enter the country illegally, because it doesn't apply. You are a legal permanent resident. You cannot not enter the country illegally unless, you cross the border without your green card. I don't know. But in that case, you would say, I don't accept the charge. That charge doesn't apply to me. If you were driving drunk and, they arrested you and you go to court and they tell you, well, your charge is domestic violence. You're like, nope, it's not. I didn't do any domestic violence. It was a DUI, right? They can't take you to court for the wrong charge. So that's why you accept it or you say no. If you accept the charge, yes, that's fine. I did cross the border. I'm here legally. It's the proper charge. That doesn't mean that automatically they're going to detain you and arrest you and send you back home. It just means that that is a proper course of action. And then you present the reasons why you should stay here, your relief. That's what they call relief. Why you need, that's your defense in removal court, why you should remain in the United States. That could be VAWA, your visa, asylum, 42B, which is cancellation and removal, 42A, which is cancellation and removal for certain legal permanent residents. So you have a green card and you're saying, please forgive me, I messed up, I will do it again. If the charge is not the correct charge, and you say that's not the correct charge, and then the judge could either say, I'm going to analyze this. Nope, it is. Sorry. Or the judge could say, let's set up a proof hearing where the prosecutor, which is the trial attorney, has to prove that they charge you with the correct charge. So they have to prove that the charge under, if it's your situation. And if it doesn't, then the judge basically says, we're going to dismiss this. And this happens a lot when we have a client who has a green card and they're being put in removal proceedings because something happened. And we fight the charge because we find that even though they're using this charge that applies to legal permanent residents, it doesn't apply to my client because maybe that charge applies if he was selling drugs, but he wasn't. It was for personal use, for example. So you need to make sure you understand the charge. You need to make sure what crimes fit into that charge. Just because it applies to the classification of your client doesn't mean that it necessarily applies to your client. You also have to know that the judges, like I said earlier, they all have different preferences. Some will ask you to submit the evidence ahead of time of your individual hearing. And in this case, the individual hearing is your trial date, is when you go and fight it, when you go and help your client fight for the right for them to stay here in this country. And that's when you have to submit all this evidence, and you have the timeline to submit the evidence and the brief, and sometimes a month. One thing I could tell you as an immigration attorney, which I still don't understand till this day, is that these guidelines of when submitting the evidence apply to you as a defense attorney and also apply to the trial attorney. But I think out of so many cases I had in immigration court, the trial attorney will not submit evidence on time, pretty much ever. And it's okay that there's no issue there. And it's not, I'm not jealous, but it happens. And sometimes you think it's unfair because they just don't submit anything at all. But you have to abide by what the judge says or the court says. And, sometimes they change your judges within one hearing within one case, because those cases could run years. I mean, those cases could run 5, 6, 8, 10, 12 years. Oops, I got scared. Those cases could run for such a long time that they could change different judges. that maybe your client moved to a whole different state and now you do a change of venue, so he has a closer court, and maybe they're changing an attorney too because you don't want to travel over there or whatever it may be. Maybe now your client was a victim of a crime, and now you could file your visa and you could ask the court for them to drop the case against them because you have a U visa. So time in the immigration court case is so precious because it opens many possibilities. I would tell if you have a client or somebody show up and say, I have a hearing, that, yes, immigration court is really important, and I'm not telling them not to worry about it. Yeah, they have to worry about it, but time makes a difference in many of these cases. Sometimes people come here because there's a situation going back in their country, and over time, over all these years, it changes. The person who was persecuting them, maybe they pass away, or they get sent to jail, or something happens and now they're not in danger. Or even maybe they come here because their family is dying from hunger, and they come here and all they want to do is work, be able to send money back home and then go back home. And during this time that the case is pending in immigration court, you're able to file a work permit for them. And now your client could work and make enough money, pay everything they had to pay back home, maybe establish a business back home. And now they want to go back, and just time and appealing will allow them to do that. I'm going to go to the next one then. So FOIA and criminal records. So when you have a client that told you they have an issue in their past, like they crossed the border illegally, they got caught, they filed something with immigration court, but I don't remember what it is. They were denied at the Ciudad Juarez or the embassy because they were denied their visa or their green card because of whatever situation, they don't know. They were detained by ICE in the country, or they had an immigration case in the immigration court. You could file FOIA, which is an immigration background check. And I have the options on here, but it really depends what information you need. I think that I know it's a lot of information, so I'm running out of time, but Crystal, later on, if you want to do something more particular about these topics, I can go through them and explain to you where you would be able to file, or where it's better for the client for you to get the records from. Background checks, FBI, court records, police reports, you could do them yourself. Sometimes it's easier to send the client to go get the police report because sometimes it takes forever for the police department to release them. FBI checks, I do them all the time. I even do my own fingerprints here in office. And those are often very valuable because you could submit them as well. Some of the cases like BAWA, UVisa, they ask for a good moral character. They ask that you have a clean background, and submitting an FBI will do the trick. So clients have immigration questions. Where do we start? You need to identify their legal status in the USA. Are they undocumented? Do they have DACA? Are they documented? Are they legal permanent resident? Are they a U.S. citizen? Who is the petitioner, the beneficiary, the defendant, the victim? We talked about all these roles when it came to UVisa, BAWA petitions, court. Ask about every arrest, conviction, plea deal, fine, jail time, citation. Sometimes it will tell you, I've never been arrested. I've never been to jail, and they've been arrested 10 times. I've never been arrested. And then you ask them usually, like, have you ever been detained by the police and taken back to to the police station? Oh yeah, that happened. That's not an arrest. No, yes, it is. You still need to make sure that you get all those information, and you ask questions in so many different manners because they will tell you they haven't. Sometimes they'll say, I was never convicted of a crime. Why? Because maybe they enter into a plea deal that if they complete such and such, then it means that the crime or the conviction is dismissed. Well, the moment they said they were guilty, even if the conviction is dismissed later on, that moment, that charge will count against them in immigration court or any immigration case. Ask about their immigration past, every entry to the United States, the day, location of entry, outcome. This means that even if they tell you, well, I only entered once in 2020. Okay, but did you try to enter before? Well, yeah, I tried several times, but I couldn't. No, every single time they tried to cross and they were successful, not successful. Ask them what happened. Ask about every time they had contact with immigration, ICE, immigration officer, border patrol, the court, immigration officer at USCIS. Anytime they filed anything with immigration office or court. Ask about their family, spouse, children, parents, grandparents. Why grandparents? Because maybe you have a U.S. citizen client in front of you that their grandparent was a U.S. citizen born here, and then maybe their mom was a U.S. citizen born here, and now that means that makes them a U.S. citizen. So you need to ask about that. Ask if they have been a victim of a crime. Ask them about it and really ask details. When, how, by who did they call the police? We went over youth visas, so make sure that you go over that as well. Are they afraid to go back to their country? Why? When? How did whatever they're afraid of happen? What happened? Ask them all those questions. That might be eligible. They might be eligible for asylum, or if they're in immigration court, they could possibly apply for asylum. Ask if they have ever submitted anything to USCIS. This is super important, like I said earlier, because maybe they are already a legal permanent resident. Maybe they submitted something in the past that will allow them to fix status now. There's so many exceptions to immigration law. Identify what immigration option they have. I've posted many questions above, many topics that I discussed today. Find out which one fits. And sometimes there's no option for them. And you need to be honest, because that way they won't go somewhere else and be taken advantage. Explain what the client might qualify for. Maybe option A or B. Refer the client to an experienced immigration attorney if they have further questions. Prevent immigration fraud. No one can promise you an outcome. Only attorneys and authorized EOR representatives can represent you in immigration court. Employment work permits are not standalone. If it sounds too good to be true, seek a second opinion. Prevent fraud. I think we submitted that to you, Crystal. If you could please send it to them as materials. Hand that out to your clients. I'm sorry?
They should have received it, and it'll be on the AJ volunteer hub as well.
Perfect. So yeah, hand that out. That will that's in English and Spanish, and it will help them, be taken advantage and losing their money with people that cannot help them. Immigration tips. Victims of crime reported to the police, cooperate with the law enforcement. Avoid traveling near the Mexican border if you're undocumented or have DACA. Do not use a fake ID or social security number. Don't do it. Don't take legal advice from non-lawyers. And all cases are unique. Do not compare your case to others. Okay, so I don't know if we have time for questions, but I could answer any questions.
Does anybody have a question? I know I've tried to get some in the chat answered. And I know that there was a lot there. Oh, can Linda give a high-level description of basis for asylum?
So for asylum, you have the clients where they're eligible because they're in persecution because of race, religion, political opinion. I don't have the other in front of me right now, but also you have what's called a protected social group. And that protected social group is kind of like a catch-all. You have to come up with a really good protected social group. It could be like underage women who are seen as being property, or underage women, indigenous underage women that own a business. And that's the reason why they're being persecuted. And that's how they identify the group. Oh, she's underage. Oh, she's indigenous. Oh, she owns a business. Oh, we're going to prosecute her. So asylum could also be, you could also apply for asylum and apply for CAT, which is Convention Against Torture, and also withholding and removal. Asylum has best benefits. It has, if you get granted asylum a year after, you could apply for the green card, and it comes with a work permit. Withholding is like the next step, but the bar is a little bit higher. So you usually could win an asylum, and then if you win asylum, then they'll see if you could win withholding and CAT. But it's a harder threshold to meet. And withholding just means that you are removable, but they're gonna go ahead and just not do it right now. We're going to withhold from removing you, but you are removable if you lose. If you lose an immigration case in court, appeal for your client. That saves them time. That gives them more time, and also, the judge might make a mistake and allow you to restart the case again.
Any other questions? Well, Linda, I cannot even thank you enough for all the information you shared today. And I know you just really skimmed over this very in-depth area of law that's constantly changing. And so I really appreciate your time on behalf of all the participants and on behalf of Administer Justice. So before I hit the leave button, I'll just ask one more time if there's any more questions. And if you signed up for this webinar, you should have received Linda's slides and the two wonderful handouts that she made. It's the same handout, it's just in English and in Spanish. That will be a great thing to share with our clients. I've gotten great notes and suggestions from all of you in the chat that I have collected. One more time, if anybody has any questions. If not, I will end this. And again, thank you so much, Linda. If we were all in a room, we could clap, but I think we can only do it virtually for you right now.
Thank you. Thank you for inviting me. I'm really happy to be here. I know it's a lot of information, so I tried to cover everything as fast as I could, but there's just so many things you need to know to be prepared of. And I'm happy to help if you have any questions. My information is on the screen. And I hope that I was able to not confuse you more, but help you understand immigration. And once again, thank you so much for being here today.
Thank you. Everyone have a good day.